Today's guest started life as an industrial chemist, worked for Bristol Myers Squibb, working on active ingredients, which in itself sounds quite interesting, and is now managing partner of Tomkins, patent and trademark attorneys. I'm delighted to welcome Cathal Lane to You and Your Business. Hi, Cathal. Welcome to.
Thank you very much, Alec.
You're in the whole world, the world of mystery to most business people, called intellectual property. Would you like to tell us a bit about that?
Yes, intellectual property, I guess, is the grand term for a number of different things that kind of go together in a group. And when you break it down, the four major parts of that are patents, trademarks, registered designs, and copyright. And our business is to help people through that and how to use those in their business to succeed.
I'm dying to hear about those, but how on earth did you get involved in this business? It seems one of those strange ones.
Well, totally by accident, actually. And what happened was did my undergraduate degree in UCD, and we went to what was the Careers and Appointments Office, but we kind of nicknamed Careers and Disappointments Office because nobody ever seemed to get a job from there. And I saw an ad for Tomkins looking for somebody to train in to be a patent attorney, and it sounded really interesting, and I applied and got it. So that was it, really.
Yes, and strange enough, you mentioned to me earlier that it's not so much, while legal is a very important part, but it doesn't come in that sequence. There's two other parts which are more important.
Correct. A lot of people assume that everybody in the legal world is primarily a legally trained person. When it comes to patent attorneys in particular, you have to have a technical qualification, and to be a European patent attorney, you have to have a degree level at least. So most all patent attorneys have a technical qualification of some kind. They're engineers, they're scientists, they're computer scientists, biotechnologists, chemists, you name it, because after all, they have to understand the technology that they're helping somebody try to protect.
Yes, and naturally it makes sense, but I think you've clarified something that a lot of our listeners wouldn't be too familiar with. Explain more about intellectual property. Let's talk about patents. I think probably a good example of that, we were talking a bit about James Dyson, who'd probably be well known to most for this.
Yeah, so if we run through the four things, because people confuse them together and they're not quite sure what they want. So a patent really is for the way something works. That's in essence what it is. So usually it's a new product or a new process. Very simply, they're the two things you can patent typically. Trademark for what it's called. So you register your trademark so somebody else can't use your brand name or product name, whatever it might be. Then we have registered designs, which is one people don't know a lot about. So if you're a Jean-Paul Gaultier or somebody, or even James Dyson, Jean-Paul Gaultier, you make a cool new perfume bottle, and you don't want somebody to make one that looks the same, you can register a design, which will give you rights to stop that happening. And then copyright is usually for mainly written materials. It may even be just product literature, it may be content of a website, or it may be some music recording, sound recording, film recording. So the difference between copyright and the others is copyright exists automatically under what's called the Berne Convention. But basically, as you write a book or you record a video, provided it's original, which basically means you haven't copied it yourself,
right.
You're not copying it from somewhere else, you create your own copyright exactly then. But just to run through, let's say, a product that might have all of those things in them, just maybe clarify for people how they work differently. So, for example, if we take the Dyson Airblade dryer, which people might have seen on bathroom walls. So James Dyson has filed patent applications for the dryer, so mainly for the internal workings, and actually mainly for ways of keeping it sterile so that it doesn't blow, lots of bugs back out on your hands again. He's also registered a design for the shape of that, so that means if he's trying to protect the way it looks. And he's registered trademarks for what it's called, and it's called an Airblade. So one of his trademark registrations is for Dyson Airblade. So just putting those together, if you did want to compete with him in this kind of market, you now can't make one that works the same because of his patents. You can't make one that looks the same because he's registered a design, so you have to change how it looks. And then, of course, you can't call it the same. So there you have, in one product, three different aspects of intellectual property working together to put down barriers to competition, essentially, so that people can't, piggyback or copy what you've done. Okay.
And people are sort of wanting or prone or whatever it is to actually taking somebody else's technology and copying it in a particular way, generally without asking permission, but you might have some advice about that.
Yes. So in essence, intellectual property rights, patents, trademarks, designs, copyright are the exception to the general rule that when you put something on the market, it's free for other people to copy it. So unless you have rights in it and you have some protection, it's basically usually free to copy. So that means if I come up with a new, farm machine or something and I put it on the market and somebody else starts to see, oh, this is quite a good machine and we could do this ourselves, they can reverse engineer potentially and then sell the product, and there may be very little you can do about it in the scenario that you haven't filed for patent protection, for example.
So it's not protected just because you came up with the idea and can prove that you did that, say, 10 years ago, and somebody's now using that sort of piece of technology, but you haven't registered anywhere.
Correct. So there's no rights in an idea in your head, okay, which a lot of people say, I wrote into somebody and, they copied it or whatever. If you don't have one of these four forms, primarily, there are other forms, but one of these four forms primarily, then there's probably no legal barrier. There may be a moral barrier insofar as it may be very annoying. And I think in my business, the thing that annoys somebody the most is when they get copied exactly. So if you think about it, what's the worst thing that could happen from a business perspective? So you come up with a new product, you prove the market, and it starts to sell quite well, for example. The worst thing that could happen is that I turn up and I find out, Alec or somebody else is sourcing these from China. I'll go to the person in China who's making these and I'll get a crate load myself and I'll sell them. And because I haven't had the setup costs, I haven't had to do all the, making prototypes and testing them. And because I don't have that, I can sell them for half the price and still make loads of money. And of course, that has to be the most annoying thing ever.
Yes.
And there is something very annoying about being imitated, even if it's as a kid in the playground when somebody's copying exactly everything you say. There's something innately annoying about being copied, and humans don't like it.
Yes, yeah, they don't see. I suppose, what do they say? Copying people is supposed to be, you should be complimented by that fact.
Yes, copying is the greatest form. Imitation is the greatest form of flattery, isn't it?
That's what I'm scraping around to get to. Yeah, that's it.
But in my world, imitation is not seen as that. It's seen as quite a blood pressure raising kind of thing to happen. Yeah.
What people, I think, fail to realise is that, and we talked about this a bit earlier, you may see a piece of technology that you could integrate into something you're doing yourself. So rather than copy it, there's a different way you might approach it.
Sure. So with intellectual property rights, there's two sides to it. There's the defensive side, which everybody sees, and I take that as being, some people put it under their bed, like, a big cudgel, and they take it out and whack somebody over the head when they step out of line and do something that they don't like. But on the other hand, it's also something you can leverage, and this is the bit most people miss. So you can license it. So, for example, if you're a small Irish company and you're, let's say, able to service the Irish and the UK markets, you might be able to get patent protection in other markets and then license somebody else to sell the product there for you. And by licensing, you retain control. So it's got two sides to it, and most people think about the defensive side and going to court and fighting somebody off. What they fail to realize is that it's got a hugely leverageable side, particularly like if you take something like software. If you sign up to iTunes or Apple or anything else that's online, to a large extent you're signing an intellectual property agreement. You're getting a license to use their platform or their software or whatever it is to do certain things. And of course, when a software company can write licenses for everybody on the planet, you can see that immediately it's leverageable. And of course, if somebody copies it, then they can go after those. So the two sides are always there. But the bit a lot of people forget about is the side where it's leverageable and licensable and possibly very helpful.
Yeah, and I think that's very important because people presume so many things, and we were saying this perception is probably the greatest enemy of your industry that you're in. They're always worried. So, for example, somebody who has used maybe, say, a particular name and has had it for a couple of years and suddenly discovers that there's a much larger corporation out there that suddenly comes knocking on the door and saying, stop.
Yes, we've seen this. Without giving any particular instances, we've seen things where people have got nasty letters from large corporations, maybe, after 2 years in business. And, the practical advice is, well, you can probably try to continue and, it may be slightly grey. But, the practical advice is change the name. It's going to be less costly, more efficient, and it's probably not the advice that you want to get. So even something as simple as doing a quick trademark search, and a trademark search is the one to do, not a company name search, not a domain name search. Those are important, but a trademark search to make sure you're free to use may be something that's really important, because while your name may not be important to you now, if you've marketed yourself as a startup, let's say after 2 years, you've probably put quite a lot of money into the name, either through branding on your products or branding on materials, branding on websites, and the last thing you're going to want to hear from somebody like us is, you need to change your name, you've got a problem.
Yes. And if you're just joining us, you're listening to me, Alec Drew, on 103.2 Dublin City FM, where my studio guest is Cathal Lane, managing partner Tomkins, sharing his knowledge on the whole area of intellectual property, which is a mystery to most of us out there, but it's certainly opening up my eyes here. We were just talking about a trademark search. How does somebody do that? Do they have to go to a company to do that, or can they?
So I would say, if you want to really nail it down and be sure, you should probably get some professional advice. But there are free search engines. For example, the EU IPO, as it's called, the European Union Intellectual Property Office, has a database that's searchable. The Irish Patents Office, for some reason it's just the Patents Office, it doesn't mention trademarks, but actually it's in charge of trademarks and designs as well, has a search facility. The UK IPO, as it's called, the UK Intellectual Property Office, has a search. So doing trademark searches online and for free is something everybody can do. And the same on patents, actually. The European Patent Office has one called ESPACEnet, that's ESPACENET.com. And then if you go to google.com and put in /patents, actually Google have a search specific to patents. So I always say to people, even if they want us to do some searching for them because they feel we might do a better job,
sure,
that they should always look themselves, because you don't buy a car if you wouldn't buy a car if you'd never been in one or seen one. You wouldn't buy a house if you'd never seen one or been in one. So why would you file a patent or a trademark application without having a quick look around yourself to see what it's all about and what it does? So that would always be my advice, mainly for educational reasons, just to have a look yourself and see if you see any issues.
Yeah, there's. We were talking earlier also about so many Irish companies, and it seems to be an Irish perception about protecting everything without understanding that there are opportunities that they could leverage if they just understood what this is all about, this whole area.
Yeah, so I think one of the things is, when it comes to patents, people probably overestimate the level of invention that needs to be there to get a patent granted. And I think part of that is because if you ask most Irish people, and I can be slightly racist because I'm Irish myself.
Yes. Especially on Patrick's Day, coming up to Patrick's Day, you might as well.
Most Irish people, if you ask them to name an inventor, most people will name somebody famous like Edison or somebody like that. If you ask them to name a female inventor, typically the only female inventor is Marie Curie that most people think of, when actually there are lots of people in our society who are inventors for, pharmaceutical companies, commercial product companies, consumer product companies, farm machinery companies. There's lots of them out there, and I could name lots of names, but most people wouldn't recognize them. So I think because of a lack of awareness, and I think possibly in our education system, though it is changing, we haven't had a huge amount of IP and how it works and how you can use it. I think possibly people overestimate what's involved. So typically, I don't spend my every day going, wow, this is a fantastic idea. Wow, this is a fantastic idea. Most patent applications are for next generation stuff. You've got a product on the market, and now you want to improve, and you want to make sure that your competitors, for example, don't copy you 10 minutes after you put it on the market and make their next generation product the same as your next generation product. So typically people are filing patent applications to try and stave off some competition and move on. And it's usually relatively incremental. It's not usually, groundbreaking, new, people aren't inventing whole new technologies every day.
But there's certainly a lot of value in them once you understand what you've got and do the proper research around it.
Yes, I mean, the value, of course, isn't in the patent itself necessarily. The value, for example, would follow from the commercial success, and nobody's ever copied a commercially unsuccessful product. Yes. Because of course they don't do that. What they do is they copy the commercially successful ones. So what you want to try to do is have a patent in place so that when you are commercially successful, you have a barrier to somebody else doing the same thing as you. So, and that can be because they need to speak to you, so they need to take a license if you're willing to give a license, or if you want to be probably a little bit more greedy and keep everything to yourself, not something I recommend, but
yes.
You could, say, I'm the only one who's going to make this product and sell it.
I mean, certainly in terms of Tomkins, if people want more information about this, what's your website that they should be looking at?
It's tomkins.com. So it's Tomkins. There's no H's or P's. We get, because of names down in Cork and elsewhere, we get people looking for us with H's and P's in there, but there are none.
Right.
So we're there, and we're in town in Dublin. So.
Tell me a bit about the history of Tomkins. Just seeing that we're just talking about the website.
Yes, so Tomkins it's an interesting firm. It's been around since 1930, which is quite remarkable, really, in this day and age where things change so fast. It was founded by a UK guy called Arthur Tomkins, who came to Ireland in 1930. Why did he do that? Well, basically Ireland had just enacted its first IP legislation in 1927.
Wow.
And they made it a requirement that if you wanted to be a patent or trademark person, you needed to be here in Ireland. So he saw an opportunity as a 30-year-old to come over and do business for his UK colleagues in Ireland, basically. And he started a business, and it's grown from there. And he retired in 1988 at the age of 88. It's easy to know his age because he was born in 1900.
Wow.
And he died in 2004 at 104 years of age, having been probably the grandfather of IP in Ireland for, quite a few years.
Gosh, it's fascinating. There's so many things in Ireland we just don't know about them, but they're fascinating. I suppose one of the things I always remember as a child, my father mentioning, there was a program on television I got interested, and it was always the Black & Decker Workmate bench, I think, if I remember correctly, it was called. But I believe that went on to be hugely successful, and then...
Yeah, so, the Black & Decker Workbench, as it was hugely successful, as I think it was sold domestically as well as into the industry. And it became a very famous patent case, particularly in the UK, actually, and it's still quoted today as being kind of a leading case law. So the issue that arose there was so firstly, to be patentable, you have to have something that's new and is inventive, right? So Black & Decker filed for this workbench, and one of the mechanisms in it was the clamping action of the top surface. So basically the top surface of the bench splits in two, and then you can wind it in and out so that it'll clamp something in the middle, pretty much like a vice or something else. So others who wanted to compete with this very successful product tried to get the patent knocked out in the UK courts, and they challenged the patent. One of the things they cited against as being what we call prior art, which is older technology, was this bookbinder, which essentially was a clamp that you put a book in to when you're gluing your book together. So you put your cover in, you put your pages in, and then you put your glue in, and then of course you clamped it for a while to hold it to make sure the glue set and the pages all didn't fall out when you took it out. And this was cited as being the closest thing to the workbench feature of the clamp on the top of the bench, and that made pretty useful case law. In fact, it was I think my memory is the Black & Decker case patent stood, even though that this was quite a similar product. And this is always the case, I think, in the patent world, is, you might have a new idea in an area, but there may be something similar either in the same area or in a different area.
Right, and there's it's amazing. I've seen programs where people kind of go off into the archives looking for ancient things. There's some amazing pieces. I mean,
yes. So I would say to you, like in the patent databases in particular, there are lots of ideas that never make it commercially. So one of the things, people come to us, they say, well, I don't see anything like that out there. There's nothing on the web. I can't find anything. I tried to source this product. And then we go to the patent database and we discover that, for example, the first dishwasher was invented in 1870, and when you see the drawings of the dishwasher, it's a cage, it's a box with water pumped into it with wire baskets in which you put your cutlery, and it looks remarkably like the one that exists today. But of course, it was probably 100 years before its time in terms of electronics and other services and kind of thing. So the patent databases are full of ideas that maybe were ahead of their time a bit, and are published ideas. So it is definitely worth searching there.
Yeah, there must be. Is there a life expectancy or a life of a
yes, patent? So the maximum term. So if we run through them quickly, a trademark can go on forever. You can renew it every 10 years. A patent has a lifetime of 20 years. Now there are a few small exceptions to that, but in principle, so after 20 years of having your monopoly, then it goes back and anybody can use it. A registered design, typically the term now is 25 years.
Right.
And copyright depends on, it's usually based on the life of the author plus 70 years, but there are different terms depending on what it is. So, for example, I think Joyce's materials came off copyright some time ago because he had died. And this is why William Shakespeare stuff, lots of people can publish it, of course, because copyright free. William Shakespeare having died, I don't know, was it 1700s or 1600s?
Oh, yes, we're going back a bit.
Some long time, much more than 70 or 100 years ago anyway.
It's interesting, I was looking at something recently, and I write an article which includes sometimes Aesop's fables, which go back about 2,000 years, but I saw copyright underneath them, which I thought was quite interesting. You know, can somebody copyright?
So this is where it gets interesting. So say, for example, I was to take a work of Shakespeare and I put it into a format, you know, maybe with illustrations or whatever. There may be some copyright in the new bits that I've added, in the sense that it may be in the layout or even the font if it's a new font, or, you know. But in general, the text, there's no copyright in the text. And this is where, you know, people sometimes get confused, I guess, or don't understand that the protection might be in something very specific, and as long as they don't take that specific thing, they are okay. So I have an example where I had a guy who had a machine in his factory, and there was a patent number on it, and he said to me, who I just happened to be there, he said to me, well, by the way, when you're here, can you tell me what this patent is? And the patent, when I looked at the patent number, it was a UK patent number. So I firstly said, well, we're in Ireland, that's a UK patent number, so it has no effect in the 26 counties. Some people forget Northern Ireland is UK, right?
Yes.
Though that might change sometime soon.
That's a contentious issue. We won't get into that.
No, we won't do that. And it was an old number, so I said to him it's likely to have expired. So when I found the patent for him, because I just looked up the number in this Spasnet database that I mentioned. I sent him the copy of the original patent. The patent was way over 20 years old, so it had expired. Secondly, it was UK only, so there was never an issue in Ireland with infringing a UK patent. And thirdly, it was for a very specific material that was used in a roller on the machine. It wasn't for the whole machine. Right. So provided he had never taken that specific material, he would never have had an issue with that patent, even if he was active in the UK, and he wasn't.
Yeah. And if you're just joining us now, you're listening to me, Alec Drew, on 103.2 Dublin City FM, where my studio guest is Cathal Lane, who is managing partner of Tomkins, and we're talking about intellectual property, which covers patents, trademarks, designs and copyrights. It's absolutely fascinating. We've learned more today about this, well, I certainly have, than I probably have in the rest of my life. People sometimes think they're protecting themselves by putting a little circle in TM or something like that on something. And
okay, so there are a number of different things, right? So you can put, let's start with C in the circle, because that's for copyright. So that's pretty easy. So if you write an original piece or you record an original piece, you can put a C in the circle because you own the copyright. TM is short for trademark, and it's usually in a capitalized TM as a subscript on as a superscript behind a name. That indicates trademark. That just means you think it's a trademark, okay? It doesn't necessarily give any rights. So if you're scared off by just TM, the thing to do is go do a trademark search and see if this is actually registered as a trademark. It does indicate that somebody thinks it's a trademark, so even if you start to use it and they haven't registered, they can come and complain that you're copying them, right? But the one to watch out for in particular is or in a circle, which is registered trademark.
Ah, right.
And or indicates that it is registered. So if somebody uses the or in a circle, it should actually have been registered as a trademark, going through the right processes. And of course, it is actually an offence to use or in a circle to indicate a trademark when you haven't registered it. So please don't use it if you don't.
Yeah, so I mean, the sort of TM can be a bit of a bluff type thing to keep the
correct
uninitiated away from you.
You could argue a lot of intellectual property is a bluff, you know, because
right.
if I put a patent number on my marketing materials, or if I just say this product is patented, I suddenly create this, you know, air of mystery about what actually somebody can protect. And, you know, people do, if people don't look into it, they can stay clear of things that they actually may have been okay to do in the first place.
I suppose it would be remiss of me in speaking to the managing partner of Tomkins not to talk about a high-profile case recently, Supermax versus McDonald's, of which you were the main people involved in it.
Yeah, so we did some of the submissions on behalf of, we did the submissions at the European EU IPO office, which is the trademark office for European Union trademarks, and we filed the submissions on behalf of Supermax to my business partner, Hazel Tunney did that. on behalf of Supermax with a view to, trying to free up some space to use the Mac word.
Right.
And as a result of the stuff we filed on behalf of Supermax, the Big Mac trademark was revoked at the EU IPO trademark office, and it caused quite a lot of publicity and controversy.
I'd say. I mean, without going into much detail, what was the sort of nuance?
So one of the things in trademark law is that in order to keep your trademark registration live, so I guess firstly skip back a little bit. If you want to register a trademark, you have to list specific goods and services. So you can't just, register Apple for everything. You have to say it's for computers or it's for baseball cats or whatever.
Yep.
And McDonald's had quite wide-ranging trademarks in defense. They were registered for lots of stuff. So Supermax saw an opportunity maybe to limit that down, because there's a principle in trademark law that if you don't use it, you lose it, basically. So if you're not using, Big Mac for other things other than burgers, for example, then there may be an opportunity for somebody else to get your trademark limited back to the things that you are using it for. And that's where Supermax took an action and were successful. In fact, they were more successful than probably anybody would have expected.
Right, so possibly it ended up working against McDonald's to even take them on if they'd let them do it.
Well, McDonald's, are like all big brand companies, are very, very possessive about what's used and what's not used. So it's no surprise that they wouldn't be offering to allow people to basically move in on their patch, or whatever you want to call it.
Yeah, I must say it's been a fascinating talk here today. That's all we've got time for here today. A special thanks to my guest Cathal Lane of Tomkins for coming into the You and Your Business studio today. Thanks also to George, who's on sound. And don't forget that you can contact the show by emailing yourbusiness@dublincityfm.ie with your comments and suggestions. The podcast of today's show will be available on dublincityfm.ie from tomorrow. Thank you for your company, and please remember to join me, Alec Drew, again next week at the same time, 12:30, right here on 103.2 Dublin City FM for another edition of You and Your Business.